And so if you're concerned, if your family is headed to probate, or if you're scared, hey, we're headed to probate, we don't want to go through probate, then you should schedule a complimentary probate needs assessment with my team. And in that assessment, my team will go over the proactive planning strategies so that you can avoid probate altogether. In fact, they will be going over the four critical documents that you need in Ohio to protect your family, being a trust, a will, a healthcare power of attorney, and a financial power of attorney. In addition, they'll be able to explain to you why going to probate court is failed planning, right? If you have a will and you have a trust, then you don't need the probate court to transfer your assets because the process that Natalie and I just went through doesn't happen overnight. In fact, it takes 9 to 12 months to fully administer an estate. And in many cases, it takes much longer. But if you have those four critical documents in place, you'll be able to avoid the probate process altogether, and your loved ones will be able to transfer your assets immediately. Another thing that Natalie and I see all the time, which is why proactive planning is critical, is because from time to time, people's loved ones will be in some sort of temporary incapacitated state. And in that state, they need a legal guardian, right? And so what happens is they don't have a healthcare power of attorney, they don't have a a financial power of attorney, and so they need to contact the probate court to appoint them as their legal guardian, right? Their legal guardian to make healthcare and financial decisions. And Natalie and I have worked on multiple cases where we've petitioned the probate court to appoint somebody as an administrator, but the loved one passed away prior to the probate court appointing them as their legal guardian. And so that's why it's critical to do something now. And that's to get those four critical documents, including the healthcare power of attorney and financial power of attorney. Because under Ohio law, if you have a healthcare or financial power of attorney, then the probate court cannot issue you a legal guardian. I repeat, they cannot issue you a legal guardian because the way the court looks at it is when you had your sound mind, you decided who you wanted to take care of you and make healthcare and financial decisions on your behalf.